I am Abhiruchi Lakras, the social media manager at Legal Law Forum. We at Legal Law Forum endeavor to promote legal education and awareness through various legal educational activities. LLF Talks is a small step towards achieving that goal. Today, in episode 6, we have with us the very talented Kajal Punjabi ma'am, and we are going to discuss with her the various aspects of corporate law. Ma'am, please take over.
Thank you. Thank you for the introduction. Um, yes, so I,
Go on, please continue. You're saying something?
yes. So I start with an introduction to corporate law. So basically, corporate law encompasses a wide spectrum of rules and regulations governing the functioning of various body corporates. For instance, companies, partnership firms, limited liability partnership firms, and nowadays we also have trust. So, for instance, we can have venture capital fund, we can have alternate investment fund. These are bodies which are incorporated in the form of trust and are required to be registered under SEBI. So, corporate law, I think, would encompass even regulation of all these kind of bodies as well, legal entities as well. I think in law school days there's a misnomer that corporate law is a involves only regulatory aspects of it, but I explain my viewpoint in the coming time. But for now, I would like to say that corporate law today is so wide that it can be best explained by using a quip from international theorist Jacob Weiner's quote: "Corporate law is what corporate lawyers do." So it's extremely wide and it's very interesting field as well.
Okay, ma'am. Ma'am, can you brief us about what is involved in corporate practice?
Yes. So, firstly, as I mentioned, it's not only regulatory aspects of it. I believe there are two branches. One is transaction part of it. One is dispute resolution. So, dispute resolution also involves corporate law. Transactional part of it would be, say, mergers, acquisitions, and documentation relating to shareholders' rights, directors' rights, articles of association of a company, then compliances relating to listing and delisting of shares. So I think corporate law would denote regulation and functioning of all these kind of and when I say corporates, it would also include regulation of societies because nowadays it's become so wide that you cannot ignore one aspect of it. And corporate law will also involve public international law when you are dealing with cross-border transactions. So when one of your parties to a transaction is a foreign party or international or a party which has international operations for that matter, you would have to be aware of the cross-border regulations or of laws relating to that jurisdiction. Also, not only this, but even I think constitutional law becomes important.
Okay.
That's because, say, if you take, for example, a statutory body like the Registrar of Companies in case of corporates, if that Registrar of Company is not acting in accordance with or not performing its functions in accordance with law, then you can invoke the jurisdiction of constitutional courts and you can remedy that situation. And in that case, constitutional law would come in aid. Then there are accounting standards, and I think these are relating to the transactional part of it. But while you're doing these documentation relating to shareholders agreements and articles of association or term sheets, I think day in and day out there are disputes arising from these documents. So when parties are acting in good faith and everything is going on smooth, these various clauses and these contracts are taken as a matter of course. But when things go wrong, or one party wants to, with ulterior motive, create some issues, each and every term in these contracts is looked at with a magnifying glass.
Okay.
And that's when your drafting or your actual focus you paid, attention which you paid while drafting the documents comes into play, I think. One instance would be, I think, which we all nowadays, we talk about it a lot, is the arbitration clause. So ordinary arbitration clause is like a midnight clause. because that's the clause which gets settled in the end. And people think, everything's going to go on properly. You've included the commercials. Now, why do you need to look into anything else? So, arbitration clause is just put in at 4 a.m. And then, because of these arbitration clauses, that it is so important, because if anything goes wrong in the document, anything goes wrong in the transaction between the parties, this is the clause which both the parties are bound by and are going to rely upon it. It would determine what kind of disputes out of this agreement could go to arbitration. Who would be the arbitrator? How many arbitrators need to be there? How these proceedings are to go on. For instance, if a contract is of a small value, say it's a very small commercially insignificant which is involved in the contract, and you pick up a standard arbitration clause of having 3 arbitrators and you put in that contract, it doesn't make sense. It will frustrate the arbitration because the cost of the arbitration will be more than the entire contract value. And these things come in place only when you're aware of the legal practicalities and laws governing these documents. It's not about just drafting documents, by taking clauses from here and there. It's about knowing these practicalities and then taking a conscious call as to what you must insert in documents relating to your facts and situation.
Okay.
Also, as I was mentioning about corporate law, the first part was transactional part of it. The second would be disputes. Now, disputes could be of 3 types. One could be between the management and the shareholders of a company. Another could be amongst the shareholders, and third could be between the shareholders and stakeholders outside the companies, like the employees or the creditors. So the law provides for conflicts between all these 3 kind of parties. And while dealing with this, the law also provides a remedy under the Companies Act to the stakeholders under Section 242 for shareholders to invoke operation mismanagement provisions. So we see in detail later on, but that's how corporate law, I think, involves transactional part of it and dispute resolution.
Okay. Ma'am, one more thing. One of our audience was saying that the camera is, can we shift it to the vertical side if it's possible for you?
I try. Sorry. I think when I do vertical, it's going to maybe fall off.
Because when we, later on when we put this on the IGTV, it will be.
Okay, it's going to be. Let me just try. Sorry.
Troublesome, we can go from that as well. No issues.
Sorry?
If it's troublesome for you, we can go back to that as well. No problem.
I think this is fine. It won't fall off, yeah.
Okay. Ma'am, while you were talking about corporate law, you spoke that you told us that constitutional law is also very much so of constitutional law is involved. Which other laws a person, as a law student, should know to start their practice as a corporate lawyer?
So I think the first is the basic triangle which we are all aware of: Companies Act, Securities Exchange Board of India Act, and Contract Regulation Act. These are the basic ones. Then surrounding them would be Contract Act firstly, then would be Foreign Exchange Management Act, Competition Law, Insolvency Bankruptcy Code, then the Income Tax Act. Nowadays even goods and service taxes become very important. Then, for example, if you're dealing with a particular business structure, like, a limited liability partnership, then you need to know, obviously, the Limited Liability Partnership Act as well, and the Companies Act, Partnership Act. And if you're dealing with a particular very peculiar business, like a mining business or banking or bank, for example, then you need to know the banking regulations, you need to know the mining laws, you need to know the labor laws. And surrounding all this, I think it's an over-encompassing importance is of general commercial laws, which is Arbitration Act, Negotiable Instruments, and Trust Act. All these will come in place somewhere or the other while you're dealing with these corporates. I think the more laws you add in the list, the better it is. These are just
I was just taking a note of Like, okay, there's so many of them.
This is
I
just it.
think, yeah, the funny part is that we are not really taught all of these in law school. Like, only a few of them are being focused on, right? So personally, we have to individually work on these, learning these aspects as well. So I guess that will be very beneficial for us. Okay, ma'am, you were also, talking about the three parts of corporate law, and especially I believe dispute resolution, arbitration, mediation, and one more. So, can you brief me more about that? If it's
Yes. So I think two parts of it actually flow in the sequence of which they occur. So first, obviously, as a lawyer, you're supposed to, get into understanding a client's requirements and then draft their documents. While drafting the documents, there would be negotiations and there would be a requirement on your part to check the regulatory aspects as to what is permissible under law and what is not permissible. You cannot put anything that's not permissible in your contracts, of course. So you need to be aware of that and then draft the documents. Once you draft them, you need to think about what could happen in case of a potential dispute. If a dispute arises in future, how are you going to protect your client? What is going to come into play at that point of time? Because where documents are drafted, as I mentioned earlier, people don't really envisage that things might go wrong, but you need to know that in advance, think about it, and then draft the documents. And in spite of doing that, if actually things go wrong, then would come your second part of corporate law, that is dispute resolution. Then it could be either by arbitration, which we mentioned if you have an arbitration clause in your contract. If you don't have an arbitration clause, then of course you would have to go to courts. And then I think it gets into a pure litigation part of it, where every law is going to be involved, not only your corporate law, but also your CPC and other provisions of substantive or even Evidence Act for that matter. Everything is going to come into play.
okay. Ma'am, so there's like, it is very important that arbitration clause is in the contract, because if it's not there, then we'll directly have to go to the court.
Yes, that all depends on what parties want. Some parties actually don't prefer having an arbitration clause, and some do prefer. So it all depends on what parties. Nowadays, it's become a trend to have arbitration clauses because it's looked at as a faster dispute resolution, and because of the latest amendments as well, which require the arbitration proceedings to be completed within a specified time frame. So I that's a encouraging step towards having arbitration clauses.
Okay. Ma'am, one more thing. What if there's a contract and there isn't an arbitration clause in it. Initially nahi tha. But if the company wants to, does not want to go to court. So then what comes in?
So then you have a provision under the Arbitration Act Section 7 which lays down what could be different types of arbitration agreement. One of them could also be by exchange of correspondence. So I think when parties have initially not included in their contract that they would go for arbitration, subsequently when disputes arise, they can tell each other that okay, let's go for arbitration, and both of them are ad idem and both of them agree that yes, we can go for arbitration. That itself becomes an arbitration agreement, and then they can refer their disputes to arbitration.
Okay. Okay, ma'am, one more thing. Which qualities do you think one should have to start a corporate career?
I think I would give a very general answer because not only corporate but any career as a student of law, we should have is firstly, I think focusing on your academics while you are in your law school, because academics come into play a lot in your foundation years. It's going to help you a lot, of course, your basics. And those foundation years would obviously be stepping stones towards your future. So it's going to help you throughout. Second is having an eye for detail, like, paying attention to details and being analytical. So whenever you're reading a provision from a Bare Act, try reading the Bare Act actually as much as possible and not from, directly or other reference books. If you're reading the Bare Act, try and deliberate and try and have an attention what term is used, why this term is used. Try using your analytical skills towards it. And when you're in law school, try and participate as much as possible in your debates and moot courts, because the more you deliberate upon your ideas, the better you understand them. Also, the better you know how to convince others with it. How do you articulate your thoughts? How you put it forward? Utilize all these opportunities, because these are not going to come back ever. Your school, your 3 to 5 years, whatever it is. So it's going to be very useful in your future. Utilize all your opportunities. Another thing is, I think, which is ignored nowadays, is to read commentaries. Even if you're studying for your exam, try and go beyond your reference book. Try and not restrict yourselves to only that subject or only that portion of which is going to be asked in the exam. Go beyond it, because that's what will actually be in use in practice. And another important thing is to write as much as possible. Start writing articles. Moment you start writing articles, you get confident. Okay, and that's a huge thing, to have confidence in your skills of how you think, how you write. That is the most important quality, I think, as an advocate. So writing would help you long way.
Okay, ma'am. So writing part is involved in the drafting skills as well, right?
Yes, so yeah, exactly, drafting skills. And because when you're drafting these contracts also for your corporate law part of it, many of these clauses are standard form clauses, they're referred to as boilerplate clauses, which which mostly advocates just put in from some standard form contract and they paste it. These clauses usually are overlooked because nobody understands the relevance till things go wrong.
Okay.
So I think that is one important aspect which needs to be studied.
Ma'am, can we discuss more about these boilerplate clauses?
Sure. So these are basically clauses which are, as I mentioned, standard term clauses which are picked up from standard contracts and put in, because there's a reason behind it, because these are neutral clauses. So they are for benefit of both the parties. It's not one-sided. So it's like a good drafting or housekeeping work which you do once you're done with the main contract. You just insert them. These clauses would be like, say, the no waiver, like parties by not doing something do not waive their rights under the contract. That would be a no waiver clause. Then there would be a notice clause, that parties are required to give notice at this address or this email address or contact details, whatever. Another could be a major one is no, I think variations must be. So if you have a written contract, it says that any variation to any term of this contract should be in writing. You cannot have an oral modification. Another thing would be an entire agreement clause, to say that this is the agreement. There's nothing beyond this which can be looked at by the courts while deciding any dispute between the parties. And that becomes extremely important, because when you're drafting any document, there is a possibility that when two parties are talking and they're negotiating pre-contract period, they would have acted upon each other's representations, which are not usually in writing. They just say that, this is how I'm going to do it, this is how you're going to do it, and we agree upon it, we act based on this. But not necessarily all these representations or these acts are going to be put in writing in the document.
Okay.
The moment you're not put in the document, and the moment you have this entire agreement clause as a standard form, you copy paste it from somewhere, you put it in, and then you realize, oh, you're stuck with this document now. Now, if one party goes, beyond the written contract, you have no remedy, because courts believe in enforcing the written terms of a document. They say that the intention of a contract must be gathered first from what they have written, then by their conduct. So if you are in writing, you have said something, courts will abide by that, enforce that upon you, because that was your intention according to courts. So these kind of clauses become very important, and their importance is noticed only when things are not proper, and when you're drafting everything is fine, but one application is problematic.
Okay. Ma'am, one more question. What are your tips for law students to polish their drafting skills? How do we work on it?
So, I think during your law school time, drafting skills, the only thing I can think about is firstly, I think when you're doing a moot, you draft your memorials. That's one place where you start writing your drafting.
Mm-hmm.
Second is writing articles. As I mentioned earlier, this is where you will start drafting. It's not like contract drafting, it's very different from contract drafting, there's no doubt about it. But that is when you start writing and putting your thoughts in writing. So actually, contract drafting is same as putting your thoughts in drafting, in writing. It's just a different mechanism. There's a typical language which you're supposed to use. And in court drafting, like in your memorial drafting, that's the court language you're supposed to use. But everywhere one string runs through all of them is to put your thoughts in writing. So that as a student, you can begin with writing articles and writing for, whichever blogs. Nowadays, there are so many blogs coming in online and there's so many raw reviews. I mean, you should just keep reading and writing. So that would help you a lot in your drafting skills as an advocate in contract drafting.
Mm-hmm. Okay, ma'am, one more thing. While we are discussing about writing articles, if we, many of our, we had asked people to write us questions which they would like to know from you.
Yes.
They would like you to answer. So one of them was, how do we apply for internships at a corporate firm? But while we are on the topic of article writing, is that really considered while our resumes are being checked? I mean,
Yes, and but not writing for any random raw blog or not random articles. But if you have a reputed publication on your CV, definitely weight of your CV increases, no doubt about it. And many recruiters look for that skill because there are it's just a general thing that advocates supposed to speak and just some people great oratory skills, no doubt about it. But when it comes to writing down, they might not be so good. And that is tested only when you can get published in a reputed journal. So that is like it's like a certificate or a proof of your writing skills. So definitely it helps you a lot in your internships and obviously for your later on positions as well.
okay, ma'am. Ma'am, one more question we have from our audience, which says, what are the things a student should learn or do practice in relation with corporate law to efficiently face the corporate world as a fresher?
So, as I mentioned, you should obviously take all your opportunities, but other than that is to continue your endeavor to learn, to keep reading and keep yourself updated with your, like whatever latest amendments come in, whatever latest judgments come in. There are many online articles available, many, websites which provide a detailed analysis of them. You must, as a student who's, is ambitious of having a career in this path, should keep themselves updated. That would be like a, distinguishing factor between you and others. So if you have that skill, you have that knowledge, it's going to help you a lot.
Okay. And one more question we have. How to know full details of drafting skills?
Details of drafting skills. So basically there is no act, which gives this is how you're supposed to draft, but it all evolves. Like this law is evolving. Today you have judgments which say that this is how a clause is, this is how the court interprets this clause, and that is I think a place where you learn from to see that courts read these clauses in this manner, so I'm supposed to put in these clauses in this manner. That is where each of your latest judgments will help you, where you know how to put in things, how courts take it, because drafting, obviously another thing is to make minimal. If you are receiving a draft from the other side, for example, we all hear this from our seniors, you should try and make minimal changes, but that skill of minimal changes is not about not protecting your client's interest. Protect your client's interest, but make the changes in such a manner that the other side also feels like yes, all our interests are protected. So that is a sign of a good draftsperson who can balance, just not have one-sided documents with all terms. Everybody can do that. You can all have one-sided documents, but that's not the skill. The skill is to have a balance between the two. and that comes with time. Of course, it comes with time.
Okay, ma'am. Ma'am, one more question we had from our audience, which was that we have heard about this term corporate governance a lot. How is it different from corporate law?
I think corporate governance is itself a system,
Okay.
which uh, in which the manner in which the companies are controlled and directed. So
Yeah.
it encompasses the mechanics of how a company is to function, and it puts in place a system of checks and balances between shareholders, directors, employees. We all know that divide, in companies, in corporate, basically, where management is, different from your ownership. Shareholders are different from directors. Shareholders do not manage the company. So it's someone else's money being managed by somebody else. So that's a reason why you need checks and balances. You need to ensure that the management is functioning in a particular manner. And previously, I think corporate governance was only limited to publicly traded companies, but now it's more about having your allocation of risk and returns in firms' activities amongst the various stakeholders in a firm, and this would involve even private companies. So today the scope has widened much more than what it was earlier. I think the corporate governance thing also started in 1990s, and then subsequently SEBI came up with its
Mhm.
listing clause 49, where it had certain clauses for only listed companies, how their boards are to function, how they are supposed to put in a system of internal controls, disclosure requirements. All these were there earlier in clause 49, and subsequently all these have been adopted in Companies Act and SEBI regulations. So today there is a need of maintaining this corporate governance mechanism, not only in private but not only in public but also private. And they're
Mhm.
very basic things, it's very easy to understand. Like for example, the first thing would be having a clear distinction between roles and responsibilities of a chairman of a company and a managing director, so that
Mhm.
you avoid having power in a single hand. That is how you promote balance of power, and
Right.
that is a basic thing which I think we all are aware of having a
Mhm.
proper system and making answerable a team. You need to have a balance of power. You cannot have it in one person's hand. That's where misuse of power can happen.
Right.
Another thing I think SEBI has incorporated now is of having a nomination committee, which
Mhm.
would have independent directors, and independent directors itself is, I think, a step towards corporate governance.
Yes.
So that would help you in, determining what kind of decisions the board of directors are supposed to take and what direction they must go towards. Then another important thing came up because of these various scams, like the Satyam scam and everything,
Yes.
was auditors and related party disclosures. For auditors,
Mhm.
it was including a mechanism for rotation of auditors. So one auditor cannot stay in your company forever. They have to, keep changing. And that is where it becomes important, because if one auditor is with you, we all know how it can be
Yes.
manipulated. So that is why it was important to have this system. So all these corporate governance provisions which we are looking at and which we look at in daily lives are as a answer or as a reaction to something that has gone wrong.
Okay.
So is within corporate law, it's not separate. It's a very important component to maintain that checks and balances. And these corporate law, corporate governance mechanisms, what we spoke about, was within the company. So, having these independent directors, having these committees is within the company. There is a system of check and balances outside the company. And that outside would be, say, we have the National Company Law Tribunal today, which has the jurisdiction to determine matters under the Companies Act. And
Right.
one of which I mentioned earlier also was operation mismanagement, which is
Mhm.
very widely used today. We all know about it. We all hear about it day in and day out. So National Company Law Tribunal, and then appeal goes to National Company Law Appellate Tribunal, after which it goes to Supreme Court. So that is an external mechanism to maintain checks and balances. First is internal. Internal doesn't work, then you go to external. So I
Okay.
think the ultimate authority is obviously the Supreme Court of India then.
Okay, ma'am, shall we take one more question from our audience? So she's asking that, I don't know if it's he or she, I'm sorry. I'm into my final year and I'm looking forward to go for a PG diploma. So according to you, what should I select? Corporate law, intellectual property rights, or cyber law?
So I think this is something, it's very much personal to one's own choices. So if you are interested towards corporate law only, then go for it. But it's always better to explore. So these foundation years, I believe, like first few years, even after you graduate, are the years where you have the opportunity to explore as much as possible. Don't restrict yourselves. If you have even decided, for example, today that yes, I want to practice corporate law, and in corporate law I want to do only transactions, still give yourself that opportunity, give yourself that time to explore and to learn other areas of law as well. Don't restrict yourselves from day one. Because I believe, and it's my personal experience as well, when you give yourself the opportunity to explore, you learn much more than what you would have, by restricting yourself. And specialization shouldn't be your day one. It should come with, with time. Once you have seen the universe, then you select one thing. Before seeing the universe, don't just jump onto one conclusion. That's what I would say.
Okay. And one more question. She's asking that how to write a good research paper.
So I think best answer would be to work very hard towards it. Working hard would involve reading other, if you have a research paper which is often written about a topic which is, very common, try searching on the internet, other articles, well written articles, read them. It's nothing wrong to, borrow ideas from other places. You can read them, analyze them, read judgments if they're available on that topic. See the universe, as I mentioned earlier, see everything, whatever you can, do your deep research, and then sit down and write articles. And writing research paper, of course, is not easy. It takes a lot of efforts. But if you have this, this willingness within you, it is possible. Just sit and read as much as possible and write down. And writing down, I think, one tip which I've heard, my seniors telling me is try and take notes as much as possible. For example, if you're attending any lecture in college, of course, or if a guest lecture, someone comes in to talk, or you're reading some judgment in your workplace for some, internship project, that time try and take notes and see how these notes will actually help you when you go to sit to write. Because I think like when we are interning, most of our topics of article writing comes from our internship projects. So that's where we actually interact with law. So it helps you a lot. Taking notes while working on a project will go a long way even in your writing skills. So I think that would be one thing for research papers.
Okay, thank you for answering that. One last question. Ma'am, could you please tell us about your journey at Federal and Company till now? And one more thing I'd like to ask you. I also saw that you have completed the company secretary course as well. So how has that helped you in your corporate career?
So company secretaries, of course, it's a very important thing. If you are trying to do corporate law, I would recommend, you try and take up company secretary's course, because it gives you a very wide, I can say, syllabus. You have to study so many acts like companies, SEBI, FEMA, competition, IBC, arbitration, legal language. It involves so many laws, and it gives you it gives you an edge over other law students, definitely, who have not done it. So I believe it's helped me tremendously in whatever I have done. I'm into more of, I think, dispute resolution of corporate law, part of, and not pure transactional work. I do mix of both, and I believe it helps me everywhere. It's not restricted to only transactional work. I think that knowledge is helping me throughout, and it's a thing which I think when you're in law school, try and do something more than law. Just don't restrict yourselves to those syllabus, because as you saw when we spoke also, there are so many aspects of law involved which you have not heard of in your law school. but that's not how it's supposed to be. You are supposed to have these aspects while doing something else. Like if I did company secretary, I knew I was covering these aspects. Some people take up chartered accountancy, who are interested towards taxation more. So even that would be a very great addition to your uh, CV, definitely.
Okay, ma'am, one last and then we'll conclude. Sir is asking that please tell us about your journey at Federal and Company till now.
Yes, so Federal and Company, I joined in my, I think, final year, just the beginning of my final year. I joined as a article clerk because I want to pursue my solicitors. So I joined as an article clerk and I've been there for like 2 years now. And it's been an amazing journey. I've got to learn a lot and I owe a lot to the firm. I think the firm has an environment of, like training its juniors. So there is a lot of training which is not there in, like, I believe in all firms nowadays. So it has a wide variety of practice. I've been to NCLT, I've been to ITACT, I've been to High Court, City Civil, small causes. It has a wide spectrum of practice. So it helps me have a diversified idea of law. So yeah, I think that's a very important, it's played an extremely important role in my career till now.
Okay, ma'am. So that was all from us. If you want to add anything else, please go ahead.
No, I think I would like to first thank Eagle Law Forum to invite me and having this wonderful discussion. I've had a great time with you all. I'm sorry for the initial glitch of joining late. I was not very well equipped with Instagram. I didn't have an account. So I'm very sorry for that, but it's been wonderful. Thank you so much. And I really appreciate this entire idea of, inviting students, inviting people working, professionals working today, and giving some insights to students. I believe it helps us a lot. It helped me also when I was a student, and I hope it helps others as well. Thank you so much.
Thank you, Mohit. It was really our pleasure to have you today. It was a really insightful session as well. I hope we have not missed any questions. Let me just once again scroll through it in case we have missed. No, I believe we have covered it all. So yes, thank you very much, ma'am. It was a great time, very insightful.
So much.